Go bold at boldip.com.
Welcome, everybody, to the Bold Inventor Show. I'm JD Houvener, patent attorney, with my good buddy Matt Kulseth over there. Matt.
Well, hello.
Hey, good to have you on. We're here every Wednesday live, and for you who are on live across LinkedIn, Facebook, and YouTube, welcome. We're going to be having a good show today. Tons of questions came in through the week on our Reddit, Quora, and I saw 3 for you on Avo, Matt.
Oh,
so we're going to have our hands full.
Let's do it.
Yeah, so we'll jump into that in a bit. Of course, our disclaimers, as always, we're here talking about the law. In this, if you're listening on the podcast, great. If you're on the video, we're going to be sharing legal information. But as you know, no legal advice here today. Happy to take any live questions, but answer them. And just, in terms of treat us like a professor, someone who's just sort of teaching.
Yeah, a lot of hypotheticals, right? A lot of hypotheticals.
Process questions, that type of thing. And that's what we're doing. And
we're after the issue, the rule, analysis, and the conclusion, right?
Oh, wow. Hold on. Bring me back again.
That's something I learned in law school. We called it IRAC.
Yeah.
IRAC.
Issue, resolution, action, conclusion?
Or issue, rule, analysis, conclusion. I think that's it.
Wow. Dude, that's so good. I remember that.
I still use that a lot.
Yeah. Well, good. Hey, Philip, good to see you too. Happy to have you on. We got those attorneys out there.
Yeah.
Like we were just saying, some of them are smarter than us. It's awesome. We got a lot of support out there. So thank you for tuning in. And we'll hopefully create some good content, for those live viewers and for those after the fact. Did you happen to be hanging out, lurking? Maybe you're anonymous. I would like to feel free to ask a question. Even though we do have a bunch in our backlog, we'll jump to you. You got a question related to really anything decent, anything that's not salacious. Right? Like we've talked before about family, marital issues. We'll handle.
Oh we're both happily married. So marriage questions. What to get you away for the anniversary. We'll be happy to help.
How to run a law firm. How to replace air conditioning units. Fix
leaks in your house. Fix your car. Fun. Let's do it.
Very, very good. Okay, well, let me plug this in. Copy and paste our disclaimer. Cool. And then we're going to jump to some Q&A for the day. And then I've got a good Shark Tank episode of Back to School. We just sent our 2 of 3 kids back to school today.
Nice. Today was the first day, huh? That's exciting.
Yeah, Stella and Emma. Stella is now going into 4th grade, big girl, and Emma is going into 3rd grade.
Nice. So, she's a third grader. I got a third grader too.
Yeah, that's awesome. So Emma got Stella's a 3rd grade teacher from last year. So cool. That way the teacher gets the family. And then Hamilton's going to start kindergarten, my youngest.
Wow. Do they start with the half days and then go to full days, or do they go straight?
They do a gentle start, and he's actually not starting until Tuesday after Labor Day.
Okay, that's when my kids start too, Tuesday after Labor Day.
Yeah. So, and he got the same kindergarten teacher that Emma had. So he'll be a busy bee.
Yeah, you must have good kids if the teacher wanted the siblings.
Yeah. Well, yeah, it's a good point. Yeah.
My youngest had all the same teachers as my daughter until this year. So I don't know what that means either. So.
Yeah, got it. Cool. Well, yeah. So I've got an invention on Shark Tank that was pitched a number of years ago, but related to back to school. So Stay tuned for that. We'll do a critique and IP review there.
Yeah. I would be remiss if I didn't point out something very cool about back to school.
Please.
Did you know Amazon now sells boxes of all of the stuff you need?
No, but that's brilliant.
All the back to school stuff. So teachers can submit a list, and then you can just log in and buy everything you need, as opposed to running to Target 3 times.
Yes. There's no more checking of the list. So Amazon has kind of figured it out, or maybe the teachers have figured out that, hey, Amazon's selling this kit.
Someone's making money on it. So
I like it. Yeah.
I like it too.
Man, I was walking through Walmart and look all the hordes of people going through them. I don't want, but we did online delivery. We're doing more and more of that.
Yeah, we are. Unfortunately, too, it's so convenient. We still support a lot of local businesses, but when it comes to going to Target or just ordering something for next day delivery, just gonna do that.
I know. Yeah, we don't need to spend too much time on this, but I'm gonna go back and forth where like for example, my wife wants to give a tip, every single time, and I'm sort of one of those no or low tippers. Sorry, I hate to admit it, but it's like, hey, that's a service, and I assume they're getting paid an hourly wage or whatever salary. So
yeah, that's a whole other topic conversation. Like the tip. What do they call it? Exhaustion, something like that.
Yeah. Oh yeah. Yeah.
Everybody wants a tip now. You know what? We should just ask for tips from now on as attorneys.
Could you believe that? It's like, here's your invoice, and if you want to just pay more, here's where I'm going to write that down. I'm not kidding. It's so weird. But yeah, you go somewhere and it's like you're just like ordering fast food, right? And you just and it's like, well, no, I'm not going to tip you, but they're going to they ask as a required question, and they kind of make you feel bad. It's like, gosh, yeah, I hear you.
I'm a sucker. I'll admit it.
Oh, look at you! You're a nice guy.
You know what? I'm just passive aggressive Minnesota nice.
I don't think you're that way at all. We do have a live question. This is from an attorney, and I'm kind of scared to bring it up because, frankly, these guys are sharp.
Philip's gonna get us.
Yeah, he's gonna get me. So here's a question: do you file assignments at the provisional stage, or wait until you file a full utility?
I'm gonna let my friend JD over here handle this question.
Right.
This is you're the patent attorney.
This is it. Yeah. And I think what I'll say here is, just so in case anyone's wondering, assignments are when you transfer ownership from you as the individual inventor or inventors to an entity, a business entity, an LLC, a C Corp. And the question is, there's two major types of applications that can get filed on the utility side, a provisional or a non-provisional. The provisional is the less formal version, and it can provide the all-important priority date, the first file date, and up to 1 year. And so during that time of pendency, yes, we do, upon request, if it makes sense, assign the application. Right, that's a potential asset, but you can transfer ownership to an entity, even at the provisional phase.
Cool.
I haven't done it recently. Can it be done? Yes. Do we recommend it? Only if they're going to market. I think would it make sense, right?
Gotcha.
It's kind of one of those things that, okay, what's the point of it?
Right.
You want to wait for things to matriculate.
Unless they're trying to commercialize it right now, bring on other investors and assign it during the process.
Yep.
So that's different than trademarks. Okay. I'll just quickly talk about the trademark side of this question.
For sure.
Make believe there is one.
Yeah.
But if you file an actual use application, so you've already gone to market with a product or service, and you're filing a trademark at the USPTO during the application process, which here in 2024 takes about 14 months.
Yeah.
12 to 14 months. You can transfer or assign the trademark to a third-party entity. So you can do it. Yep.
Okay.
During the application process. However, if you file an intent to use application, meaning that you're not in the marketplace yet, but you're going to be, you may not assign that trademark application to a third-party firm until you submit your proof of use.
Okay. Interesting.
So that's something that trips up a lot of attorneys that I've seen.
Yeah.
They'll file an assignment for an intent to use application and get denied by the USPTO. So.
Yeah, what do you think the policy reason is there? Maybe. Is there anything much to it?
Yeah, I mean, I think that they don't want people prospecting, right? They don't want people filing trademarks and then just selling them to a third party, right? Basically holding the spot for people.
Oh, interesting. Right. Kind of like a domain squatter, if you will.
Yeah, I think that's part of it. But if you get back to like the policy perspective, right? It's not possible for a third party to have a bona fide intent to use the product or service if they didn't file the trademark themselves, right? So at the time of filing, the initial filer, the initial owner of the trademark application or the intent to use application had to have a bona fide intent to use. But obviously the third party that they assign it to or sell it to isn't going to have that same bona fide intent to use. So I think that's really what the issue is.
I like it. Well, Philip commented on I believe it was on my answer on the patent side. So he's a practitioner. He files assignments once he's carried out a full inventorship determination, which I think is really good. That is an awesome discussion that does happen. And sometimes it's forgotten. It's like, hey, if you're a solo inventor, did you invent all of this? Is anyone else involved, right? Is anyone else going to come out of the woodwork and say, you know what, I invented part of this? Let's get everybody together. And, only then I think I agree that makes sense. This, okay, are we all going to assign this to one entity? Then there's some further considerations to be made where you want to probably recommend a business attorney, to draft the, founders agreements, operating agreements where all individuals the inventors, can be on the same page with respect to any money put in or expectations for payouts, ROI. It's a really good idea too for the attorney, because what can happen is business, partners break up. And so what's cool is if you represent the company now, you don't have to fire your client, right? You have one, party can leave. You can represent, one inventor. You don't need to represent all of them. You represent the company and the company's best interest. So it's a pretty cool play. Good call, Philip. Thank you for that. All right. Keep them coming.
Let's do it.
Yeah. So let's jump to this first one here. We've answered quite a few, but this one is out of Reddit. And it kind of falls in line with what Philip's, in the same genre as Philip's question.
Cool.
This is about licensing and the provisional patent application. So let's see, I'll get this pulled up. Do you need an approval or patent pending status on the non-provisional in order to move forward with pursuing companies for product licensing? Or is a provisional patent sufficient for that type of situation? Also, how willing or reluctant are companies generally to the idea of negotiating cost of a patent being granted to a licensing agreement? The answer is yes, you may negotiate a licensing deal even at the provisional phase. And I think it just comes with an additional risk for the licensor, which is, I always get those mixed up, licensee, I should say, the one receiving the license, because they're now kind of at a big risk of, hey, is this going to get, accepted? Might like to hire their own counsel, maybe a third party, unbiased, and do their own patent search, look at the spec really thoroughly, make sure it's something they want to get behind, and they feel like they can build a product around, because they don't know what the examiner's going to say. They just don't.
Yeah, I was thinking initially, it was like, this seems like a law school question, right? Is there actual consideration here between the parties, right? Because one has like the prospect of a patent registration, and the other one presumably giving the money, right? So it's like you're bargaining for the prospect of trademark registration, right? Which I guess, that's still something.
Absolutely.
Right? May not be much, but it's something.
I mean, think of it. This came to mind. I mean, think of it if you've got a big chunk of land you own and you want to license the mining rights. Hey, I don't know what's down there. Good luck, right? I mean, obviously they're going to probably do some soil tests and they're going to do some patent research. But hey, whatever you end up negotiating, that's the deal.
That's it. That's the deal.
You can do that if that's part of the plan.
Cool.
The last part of the question is, are they going to be reluctant? Well, like I said, just a little more risk. And so I think it may be harder to do that. But again, if you can show, just like Shark Tank questions, right? Mike O'Leary, he's going to be, or Kevin O'Leary, what are your sales? So if you're in the market and you're making sales, that's compelling. And so they'd want to take a shot on it. All right. Let's jump over to a trademark question.
Goody.
This one is also Reddit. Give you at least a short question. You can't say it's going to be a straightforward one, but short. Okay, car companies. How can I use car companies on my clothing brand without getting trademark, without infringing someone's trademark?
You probably can't.
Probably can't. That's a quick answer.
You probably can't. There is the idea or the argument that, if you're displaying a brand on a shirt, like my daughter came home the other day and she's wearing this Ford Bronco t-shirt. Now, I don't know where my wife got that for her, but and I don't know why she's wearing a Ford Bronco shirt. I'm not a Ford guy. But she's wearing this Ford Bronco shirt. So I'm thinking, I had this question myself. I was like, did they license the name Ford Bronco from, Ford? Or do they
t-shirt manufacturer, right?
T-shirt manufacturer, or do they just make this Ford Bronco t-shirt, with some retro kind of vibes on it and just assume that it's okay? And my answer would be you need, that's Ford's right and ability to manufacture their own t-shirts and promotional materials and things like that. And we can't do that. But if they're not using it in So like, for example, like I'm wearing sweatshirt here. I got the logo in the upper left breast pocket area. That's trademark use. If you're just splashing that logo all over the front of the chest of the shirt or on the back,
Yep.
the government doesn't say that that's trademark use. That's ornamentation. That's decoration.
Got it.
In which case, it wouldn't be a violation of trademark rights. It might be, a violation of other intellectual property rights. Like if you're using the logo, that could potentially be a different type of trademark infringement or copyright infringement, or the likeness of the vehicle potentially could all be copyright violations. But yeah, I mean, I guess it depends, but I would assume that no, you can't be using anyone's brand on your apparel.
Yeah, cool.
Because it creates this impression that your sponsor is somehow affiliated with Ford.
Good answer. I like it. I do like the look of the new Ford Bronco. I just have to say offhand, it's kind of cool. Kind of a Jeep, a little bit tougher rank, stuff.
Yeah.
But yeah.
I'm a Toyota Land Cruiser guy, so that's from
Land Cruiser. Oh, cool.
Land Cruiser and 4Runners. Those are my vehicles.
I need to explore that. I'm still driving my Prius over here, so
nice.
Let's see. Cool. Okay. Yeah, and just one other note on that I was thinking about is, if you're going to be basically selling this as a hobby or real small time, just selling a few of these, you're likely not going to get, a cease and desist letter.
No.
If you come up with a really unique, cool, fun design, you push the marketing like crazy and you start selling it, that's when you're going to get the cease and desist. And that's where
once there's something worth going after, then you're going to get the cease and desist.
Yep. So it's really not a smart idea.
Yeah.
Cool. Let's do the next one. I see there's some live viewers out there. If you have any questions, feel free to shoot them out. Matt and I will tackle that as a priority. We've got a list of questions we're just chewing through that came on through Reddit and Quora. So this one is our Quora question. We have a couple, actually. This is patent side. That's a good one. All right. So can someone patent someone else's product, which is already in use, but isn't patented? That's a no, and even Matt knew that one.
I knew that. I might be stupid, but I'm not dumb. Okay?
Yeah, there we go. Right. Hey, well, I mean, that's the thing. It's a fair, I love it. It's a decent question. And the answer is no. I can pay two good reasons. One, you're not the inventor. Okay? That is one some people kind of forget. Okay? As you're going through considering whether to file something with the patent office, that is number one. You will swear an oath that, hey, you came up with this. You, on your own, conceived of it, brought it about, created it, invented it. You cannot seek a patent on something you didn't invent. All right. And number two, if it's been in the public, right? If it's already in use, you're saying, if it's been in use, even if you did invent it for more than a year, you're out of time. There's a really strict statutory bar for 1 year. And so if it's been out in the public for sale, or even if it's been offered for sale for more than a year, you're out of luck, even if you were the inventor. So those two kind of issues are at the heart of the answer. So sorry, you're out of luck. Not a good idea.
Nope.
We have a live viewer here. It's like Muscle.
You have an admirer.
Actually, I remember this guy. I remember Muscle. All right, JD, been watching your show for some time and a big fan of your work. Love it.
Yeah. Who is
Where's
this?
love for Matt? Come on. Notice that. No. We're part of it. Here we go. We have some follow-up. He's a founder of a VC-backed tech startup. I remember this. AI for patent searching.
Cool.
And we're looking for advisors and mentors. What's the best way to reach you for a short meeting if you're up for it? Yes. Shoot me an email. I'm always up for getting sold. No, just kidding. No, I'd love to chat.
That's cool.
But
I took some AI trademark software for a spin the other week. It was interesting.
Cool. Yeah.
Yeah, it did office action analysis and formulating generative word responses to office actions.
I'm playing around with AI a ton too. I'm having a lot of fun.
It was cool, but I would never use it in the actual. At least at this point, I'd really have to play with it in order to get comfortable with how accurate or well articulated the arguments are. They're pretty basic arguments.
Yeah. I haven't done any legal analysis type of play, but I've done quite a bit in the marketing world and content world.
Sure.
Where you can inject a really small, sometimes a 2 or 3 minute, powerful, creative, unique thought on video, and then you can really get that sort of amplified using. Cool. It's really cool, very fun.
Yeah, that is neat. But yeah,
That's
artificial intelligence, like in the legal world, it's coming. Like in the last year, I've seen it both on the search analysis side for like opinion letters. I've seen, our search provider TMTKO provides now some like artificial intelligence, like not office action analysis, but search analysis.
Yeah.
Looking for potential registration concerns, and then generative AI for office action responses. It's cool.
Yes, it really is.
Yeah, but you as an attorney, like you gotta be so careful with that, right? Because we've all heard stories of now attorneys using AI to generate motions and things like that, and they're wrong, and like they get called out, and then the bar association gets involved, and you don't want that. You don't want that kind of headache.
Right. Yeah, the human attorney has got to be in control and is responsible, of course, for what comes out of their mouth or the machine's mouth, whatever it is. And so, it'll be a really interesting balance to see where that goes. But we are at Bold. We're looking into it. We're not sticking our head in the sand. I think congrats to you and others here at Bold. We're open to learning, knowing that we're not perfect and there's always ways to improve. So
I mean, I certainly see, right now, I would say like you could use AI, or at least in my role as a trademark attorney, you could use it to, at least get you started with some analysis, right? Get the initial kind of template up and running if that's what you're into. But I wouldn't use it for client matters at this point.
Right. Yeah. Well, at least you're exploring, and we're
I'm curious. I think for simple matters, it might make some sense. Or a client who's price sensitive and, wants an attorney to file the trademark and look over it and review it, but also has cost concerns, and AI might be a way to kind of assuage some of that.
Right. Okay. We got a few more here if you're up for it. Roll up our sleeves a bit. So let's see. This one is the last one from the Cora bucket, and I think it's on the patent side. Here we go. Yeah. Shout out to Matt from Mossel. Not much experience with trademarks, but Well, you said you have a startup, so you've got to be concerned about trademarks. Any business should be worried about that. He's asking about Harvey AI. That's not something I've heard about. Have you? Okay.
No. Well, I'm gonna Google it though.
We're gonna Google muscle. Let us know if we need to build our Harvey AI muscle.
Augment your workflows using domain-specific models trained by you and for professional service providers. The legal AI platform. I still don't know what that does, but I'll look into it.
Check it out. It's on our list now. Thank you for putting it on the radar. So here we go. Here's a question. This is for me. Knowing that someone cannot legally patent an invention that is not their own. Hey, good for you. You answered the question. Would posting an idea for an invention online be proof of origin if it's an original idea? Well, that's an interesting question. So proof of origin, there is it is not who invented it first who gets the patent. It actually is who files it first. So screw proof of origin, right? If that's your concern, I think what you're asking about is it novel? Is it an original new idea? That will be determined by the examiner, right? And if you want to take a look before you leap, and otherwise before you spend a bunch of time and money hiring a professional to do the legal work of preparing an application, a patent search is super important. So posting an idea online will be a publication, right? That will be an initial publication where you're telling the world, hey, here's what I've done. And that will put that is a date, all right, where you now have up to a year to file a patent application with the U.S. Patent and Trademark Office. That is a really nice, generous grace period. Some countries around the world do not allow it. So if you want to be more conservative, I think the best shot is to speak with an attorney first before you post anything online. Do some searching, take a look and see if there's really something valuable that could be worth worth holding off and getting at least a provisional file to lock in the priority date and then publishing and going live with your concept. So, even if your goal is not to get a patent, let's say about something else that's out there, but it's not necessarily in the public view. Yes, you can just publish it, right? Just share it with the world, knowing you're not going to be able to have ownership of it because you're not the inventor. That's what's called a defensive publication. This is what's called that you're actively blocking some other entity from filing it on their own. So I think that if that's your goal, is to prevent anyone else from getting a patent on it, even someone who did invent it, that is a strategy to use. So
cool. Yeah, good answer.
That was good. All right, we're going back over the trademark land. This is a long one.
I love trademark land.
Yeah, this is trademark. This is a good one. Multi-part.
Oof.
So I had a trademark rejected for not being distinctive.
Okay.
Essentially, what I was trying to do is make it more distinctive by combining two words, but in hindsight, I understand why it was turned down. An example would be launching a shaving cream brand called Shaving Cream. I'd like some advice from people that have had a similar issue about which ways still work without infringing on the brands, but add a distinction. For example, in Co at the end, so it becomes Shaving Co. Is that going to do it? I think there's a little bit more continuation here. So it becomes Shaving Cream Co. Is that distinctive just by adding Co, sort of short for company? Any idea? Be welcome.
Yeah, no, pretty straightforward. So kind of two things here. I'll take the easiest one first. Adding Co to a brand, does that make, what would otherwise be a merely descriptive or generic trademark somehow distinctive? Does not.
Okay.
If you add a descriptor to an already descriptive trademark, you're just left with a larger descriptive trademark.
All right.
And not only is it descriptive, it's probably merely descriptive. And that's kind of the bar for, can't be merely descriptive. That's one of the bars to registration for trademarks. Back to the original question about like taking two distinct words and smashing them together, right? Creating a composite trademark from two words. Yes, you can potentially register two words as a composite trademark, but one of those words needs to be suggestive or arbitrary or fanciful. You can't combine two merely descriptive words into a singular word and expect the USPTO to allow it to register. They're never going to do that. So that's the test, is that they break the words apart, and if they see shaving, cream, you sell some sort of shaving accessories, descriptive, right? Add Co to the end, still descriptive.
Yep.
So you really need to find a brand that is highly suggestive of the product without, hitting people over the head with, what the product is. It's a fine line, right? You want to kind of evoke what the product or the service is, but you can't use the actual term or name for the thing to get a trademark registration.
Okay. Maybe a different question. I'll just ask you, so I'm thinking about it. You've got the two words, shave and nation. Okay.
Yeah.
Let's see. What are your thoughts about keeping those two words separate, or Shave Nation as one word?
Yeah. I see more and more clients going towards unitary kind of composite trademarks, one word. The reason
you're right, Pinterest, all these,
Shave Nation, one word. And I kind of like that personally because it's very clear to the viewer of the branding that this is a trademark. This is a brand, right? Mm-hmm. Because we're basically just smashing these two words together and calling it Shave Nation. Both would work from a trademark registration perspective. The word shave would obviously be descriptive and would have to be disclaimed during the application process.
Even if it's part of the same word, they would still split it off and just say, hey, look, practically this is like two.
The word shave is still descriptive. So you can't enforce the word shave separate apart from the mark as a whole, which is Shave Nation.
Got it.
But I see more clients going towards that one word trademark. And I'm generally like in support of that. I think it makes things a little bit easier. The only downside is that clients need to be consistent with how they use those unitary trademarks or those composite trademarks. What I mean by that is that, if you're going to do Shave Nation one word, then you better always use it Shave Nation one word. So if you don't think you can make that Shave Nation word or trademark work in a logo without, horizontally stacking it, then you might consider, splitting the words up into two words.
That's awesome.
So that's something that I think is really important too, is that I see a lot of newer entrepreneurs with a brand like Shave Nation, but then they're using it in multiple different iterations and formats, space, no space, caps here, caps there, so just be consistent with your trademark usage.
Yeah. I mean, it's nice. We have a little bit extra time. We can kind of take, kind of explore some of these. So, and I've seen brands evolve, right?
Yep.
where it was Shave Nation and now it's just this SN, right? That sort of looks
Yep.
like the
Yeah,
Shave.
it happens all the time.
So how does that walk us through that? How do you go after new trademarks over time, or abandon, if you will, or do you try to hang on to old
Yeah.
marks?
Yeah, good question. So, when we file trademarks for clients in the US, we're kind of given two primary options: word marks and design marks. Design marks protect logos, color, font, imagery, that sort of thing.
Yeah.
Stylization, whereas a word mark just protects the letters of the name or the numbers in the trademark. So, generally speaking, if we can get the word marks registered, that's what we want, because if the client changes the branding in the future, then they don't have to refile the new logo every time they rebrand, right? And clients rebrand pretty often. It's not uncommon for clients to rebrand every 5 years, something like that. So word marks are really powerful for that. So if we can get them, that's always kind of my first kind of push to the client is like, let's go with the word mark. You might be in multiple classes of goods and services, and maybe you don't have the funds to file in all those classes right now, but to start with, we're going to file the word mark typically. And then if you come back and you want to expand your services and things like that, then we'll probably look at filing a design mark to kind of soak up some of those other services that you're offering.
Yeah.
So I like to do kind of a little bit of both. I'll look towards a word mark first. That's kind of the primary focus for me is let's get a word mark registered. But there might be some reasons why it would behoove the client to register a design logo mark instead.
Okay. Is it true generally you can have both and, let's say you're selling, little shaver kits and all you got on the kit is this SN. Of course, on your website, other marketing, you have, Shave Nation.
Yep.
Both, they can coexist. Okay. You're not.
Yeah, it's not a problem at all. So in that particular case, maybe we do this quite a bit with apparel companies. And so the example with an apparel company, much similar to the shave company, would be maybe the website, we have the logo registered because it's prominently displayed on the website. So Class 35 online retail for the logo.
Yep.
And then we're going to do the apparel. Maybe it's just a word mark for the apparel, or maybe it's just a word mark for SN for the shave kit itself, because that's what the branding it's on the product. But I always try to get clients to, again, be consistent with the branding. So, if they have, SN for the actual kit, maybe it's SN, Shave Nation below it a little bit. So at least there's some connection to the mother brand.
Right. Awesome. Wonderful answer. We really expounded there.
Yeah, I'm real caffeinated today. So
You're on it. You're on it, my friend. Let's put our link here for anybody who's out there watching. Give us a like, subscribe. If you want to catch us live, you missed it, you're listening to the podcast, you're watching the broadcast after. We're live every Wednesday at 1:30 Pacific, so catch us next week. And for being an action taker, if you want to schedule time to talk about something you're working through, have a question about, want to talk in confidence, that's your link to do it. So,
JD, if we get any more viewers here, we're gonna have to take this thing on the road.
Right.
Selling out auditoriums.
Yeah, right.
We'll be
cross promotional deals. Yeah, we'll have placement, product placement,
product placements. We'll probably have like famous celebrities come on the show, drop in.
Yeah. We have had quite a few guests, and absolutely some of them will be famous.
Yes. Hopefully for good reasons.
Yeah. Yes.
I think we've had a couple on who might be famous for other reasons, but
Inventors come in all shapes. And entrepreneurs.
Yes, they do.
All shapes, sizes, styles, backgrounds, demographics.
We're a special breed, inventors and entrepreneurs.
Here we go. Let's finish with this one. Talking about those big, bad, huge corporations.
Oh yeah, they're the worst.
I think we represent the little guy, little gal, and so I like fighting for the right for the individual. This person's got something to say. I've seen this with almost all big companies. They have most of their IP filed by a big law firm or two, but we'll have some smaller number of patents, usually filed by a couple of small law firms. Okay, someone's very perceptive. I didn't actually know that, or I haven't seen that. Is there a reason for that? And are they good law firms to work with? Thanks in advance.
Never confuse the cost of something with its value.
Ah, there it is. Beautiful.
Yep, just dropping knowledge right there.
I mean, I have nothing. We can stop right there. I will expound because we do have some time.
Yes.
But really, You said it all. I think also what can happen with big law firms, as opposed to smaller law firms like Bold, is they have nasty conflicts, really big mammoth conflicts.
True.
They have big clients,
True.
Facebooks, Amazons, maybe even not even necessarily that big, but the big set. And they can say you're not allowed to have any other clients in.
If you represent one of those big clients, you potentially conflict out of all their vendors potentially too.
Huge. And so that could be a reason, why they've got maybe this subset where they think, this could be conflict, not even it is, but, could be eventually become a conflict. Or, hey, we just actually want to make sure we're getting good service from these big law firms. Sure. Let's go see what we get from these boutiques so we can match up and keep the big law firms on their toes.
Yep.
And so you see that a lot with all sorts of things. If you have one employee doing the role, you're not really sure if they're doing a great job because you know one to compare them against. So comparison is always good. I don't know. Do you have any other ideas why they might kind of diversify?
Yeah, no, I think the conflict one is a really, really good example. Conflicts at the big firms are really prevalent, right? I can't remember the amount of times that I've sent off some, larger trademark litigation work to a mentor of mine at one of the big firms here in Minneapolis, and he's had to decline it because he has represented, an adverse party or someone that his firm has, right? So and that's why the big firms, they hang out with the big corporations because they have to. There's no one else they can work with really sometimes.
Totally.
The only thing that go ahead.
Go ahead.
Oh, the only thing I was going to say is that, also, I don't know the file history, obviously, of all these patents or trademarks or whatever, but it's entirely possible that these trademarks and patents were filed by smaller entities that eventually formed a partnership or became part of the larger company. And they've kind of kept their existing counsel, on those matters. I know I have a few clients like that too, that I do trademark work for, who've since blown up and become huge and have moved on to larger firms. Right. But we still handle the few trademarks that, we file for them to begin with.
Right. Yeah. There's a certain amount of loyalty, to.
Yeah. I think so. And, just, inside baseball here, the pitch from a lot of large law firms is like, hey, like you're doing business law with me. Like we got this trademark patent practice. Like I'd like to take everything in house just to keep the things really clean and billing easy. And I can communicate with JD over here a lot easier because he's next door to me.
Right.
It's not really reality, but.
Right. Yeah. Well, I think that is the idea, sort of, save on the administrative costs, save on, having multiple attorneys. Sure. But you've got to weigh the benefit of that versus, are you getting the quality service? Are you getting the kind of representation you want?
Sure. And I will say, I've gone up against large corporate opposing counsel many, many times over the last 14 years. Yeah. By and large, they're very good at what they do. Big law is not hiring dummies typically. So,
no, not at all. No.
And they got lots of time because they bill by the hour. So they don't mind dragging stuff out and making life hard. So
yeah.
Whereas our clients are typically they want the best outcome for the most reasonable amount of money possible, right? So
totally. Yeah, I was going to say earlier. I think legal ethics and conflicts is a huge topic, and I think we can spend a bunch of time, on that.
Annoying but important.
Yes, and the things we think about, what we look at are two main types of conflicts: so procedural or substantive. So procedural is where you've got, hey, I know this person. I'm not going to be able to be impartial, or there's opposing side of a dispute with just the name. And then certainly for patents, and I think maybe for trademarks too, substantive conflicts where, hey, we're actually helping a client with the exact same invention, and it's super tricky. It's only come up, within this 10 years, less than 10 times, right? Where we actually, this is so close, and in those cases, we have to walk a very fine line of not telling either party
right
that either one of them exists. They're on their own, and we're just sort of the gatekeepers of that. And the cool thing about representing smaller inventors is it is usually limited in scope, right? And so we can represent multiple inventors. Let's say in athletic shoes, right? If the claim of that is all about the air properties within the chamber of the article of shoe, and the other one is about, the way the laces lace up. That's completely different in terms of what functional out. So a lot of little discrete things. versus having large portfolios from larger clients.
It's relatively easy for me on the trademark side when it comes to conflicts because, one, if I recognize the brand or, have the association like, oh, this sounds a lot like this other client's brand, right, in the same industry, right, that's going to be a conflict. I've never had that happen. But one of the rules I was taught in law school a long time ago was, if you're doing a search report for a client and you find in that search report another trademark that you've applied for on behalf of another client, that's a conflict, right? Because you can't be expected to be, fair and impartial when you're doing analysis about your own trademark work.
I like it a lot. Yeah.
But, honestly, like I think, of the 1,500 trademarks that I've filed, I think I can only think of 2 conflicts in that whole time. It just doesn't happen. There's so many trademarks that are filed and, it's rare for me at least.
Totally. Well, very good. And it's one of those things we just do as attorneys, right? It's our ethical sort of our duty to the clients.
Yep. Every morning I open that spreadsheet up, JD. Yeah. Do I have a conflict? No, not here.
I go in there whenever I get poked by a Megan to go check.
Oh, yeah. Speaking of that, I'm going to do that right now while you take the next one.
We're all done with questions. We knocked out, I think that was 7 or 8. Cool. So good work. That was a big hustle. The last 15 minutes here, we're going to do what's called a bold bite and do a critique of a pitch to the Shark Tank panel. This was a number of years ago, back to school gadget. Pretty cute, honestly. And the name of the product is called Vest Packs with a Z. So we'll be talking to you about that on the trademark side.
Cool.
So we'll switch our audio over and then get that rolling. Is that? Here we go. Audio's good?
Good.
All right, let's roll.
Is a product designed for kids to easily carry their belongings.
Hello, Sharks. My name is Michael Woolley, and I'm the Chief Financial Officer of Best Packs.
Well, hello, Sharks. My name is Arthur Greer. I am the official licensee of the Best Pack.
I'm asking for $50,000 for exchange for 10% of my company. We have added a new twist to the common vest. Best Packs was invented by my daughter when she was in 6th grade. Her teacher gave her a science project. Find a problem, come up with a solution. She thought backpacks are heavy. She created a new backpack that's more comfortable, convenient, and stylish. Introducing Best Pack. It's a Best Pack combination. Its functional design helps distribute the weight.
Great job, Mom.
I'm a model and a victim.
I've been in the backpack business for over 30 years, and I've never seen a product like this before.
Remember, you can put important stuff up front, like your money. Okay, Sharks, who wants to start putting money in your front pockets?
How much money do you have in sales?
January and February, we had approximately $10,000 worth.
Ooh, that's not a lot of money.
Yeah.
All right. Michael, what is the relationship again? You own the rights for the product, and then you licensed it to Arthur, and only Arthur can sell the product. Is that right?
That is true.
Can we see the product?
Guys, come on.
Thank you very much.
Thanks, sweetie.
I'll take the lollipop. Thank you.
Yeah, it's best to get rid of the kids because things are about to get ugly.
Good job, guys.
Great job.
Bye.
Arthur, you buy the product, then you pay a fee to Michael. What is that fee that you pay off every product?
I make 6.5% royalty. And how much do they sell for?
That one sells for $14.88 retail.
And what did it cost you to make that?
That cost around $4.75.
And the total sales over what period of time are what?
Well, what happened was last November, we signed a license agreement. We had it in a big box store for January and February.
Which one?
Walmart.
You have this in Walmart?
Yes.
How many stores were you?
75 stores.
$10,000 in sales and 75 Walmart.
Well, they gave you a
Was
test. And what happened? They delisted it when you didn't sell any?
I would have loved to gotten it out, during holiday, but it did go out during January.
Is Walmart going to reorder and sell it in more stores?
That's what I need to see what happens during back to school. We'll find out at that time.
But Arthur, just put yourself in my shoes for a moment. You're in Walmart,
Yes.
largest retailer in the world. You're in 75 stores. You've only done $10,000 in sales. That seems bad to me.
Tell us what we're missing.
Tell us why this is good news. Yeah.
But then this is very good news. That they're willing to, try something out.
Can we come back and let me give a little history? After my daughter had invented it, she won her 6th grade science class contest. Then another contest called $1 Million Idea Challenge comes up. And so it was put on Oprah Winfrey.
And still you only sold $10,000.
All right. They had a cool story.
Oh man, they got brutalized.
They got no deal. This on the update here. This was season 6, way back, I think 10 plus years ago. They were looking for 50 grand and giving up 10% equity. No deal. Kevin O'Leary was just relentless right out of the gate.
Hilarious. And
he wasn't buying any of it. He was like, sorry.
No. I was listening to the inventor or the inventor's father talk a little bit, and I don't know. Do you and your wife watch Righteous Gemstones at all? Have you watched that at all?
No, I've not seen that.
Oh, it's on HBO Max, but it's pretty funny. At least I think it's on HBO Max. But dude just reminds me of Uncle Baby Billy.
With the accent going.
Yeah, like same accent. Love it. But kind of a silly name, pretty descriptive name.
Okay.
No trademark registration at the USPTO. Not that they could afford it with those kinds of sales. So yeah, I have concerns about that brand. Cool product though, cute product, cute kids.
I think so too. Yeah, I mean, I think, and they didn't quite get to it in the video I did watch earlier. The daughter is now 26 years old. So I mean, lots of time has gone by. They've had giant opportunities. He mentioned Oprah, Walmart. That tells you that the darn thing just isn't selling. Nobody wants to buy it. And even priced at $15,
which is crazy cheap. I mean, I guess this was a long time ago, right?
Yes, 10 years ago. But let's say even $20 today, $25 today. But it's vest is kind of warm. It's good for maybe half the year. So I don't know. Yeah, it's one of those things that I'd actually rather get an independent backpack. It sort of sounds good and certainly is patentable. They did a security patent on it. I'll show that off real quick.
Cool.
This was quite a while ago, back in 2002. They have, Kristen Woolley, the father's on there, and maybe the mother too. It's maybe one of those issues where inventors,
everyone's in the room.
Everyone in the room, right? So did dad and mom really invent it, or was it really just the daughter? Legally, right? If you take a look at it, they have to be able to show that they contributed to some aspect of the claimed invention. Maybe they did, but sometimes, you'll see that at, larger companies too, where the, supervisor or manager wants to get in on the patent. Sure. They actually didn't invent anything. So, sort of here, no there, no real harm, but it's important to distinguish. Could become an issue if this thing were actually commercially viable. So it was filed way back in 2001, and then expired in 2020. This is the invention. They had a really huge claim. This sort of is a huge red flag. I mean, for relatively simple apparatus to have this much wording tells me maybe they did it on their own.
It's a vest with pockets.
Yeah, and you carry on for paragraphs and paragraphs.
A big pocket.
I mean, no one's going to infringe that. You just got to change one or two of these, elements, and you're no longer infringing. So it's a really challenging one. But what's cool is even something like this, you can get a licensee, right? We have that guy standing on stage, saying he's proud licensee. He's the only one that can manufacture the thing. My goodness, that's a very narrow claim scope.
And 6% royalties? That's not much, especially on $10,000. That's $600 last I checked.
That's right. Yeah. So just to work through what that means. So single unit costs $475 to make is what they said. Sells for $1488. I don't do licensing deals, but let's just do some real quick math. I mean, if the profit, I suppose, and maybe they got to subtract out any operations costs or marketing costs on top of that. Maybe you're left with maybe $1 or $2, and so you're getting 13 cents on every unit sold. That's not great. You got to be selling thousands, hundreds of thousands to start making real good money,
right?
At that rate. So if you're in a deal, hopefully working with a patent attorney or licensing attorney that does licensing deals, they can help you think through what's a realistic royalty rate. I did want to point out too, they didn't quite get into this, but the rights that manufacturer had was just the ability to be the only one that can make it. Now, when you get a patent granted, you have the ability to prevent anyone else from making, using, selling, or importing. So those are 4 different rights. And so I'm not sure, obviously, what the deal was, but maybe they limited it to just the ability to sell, to be the retailer, the manufacturer, and the retailer. And you can do that exclusively, right? You can say, hey, like, you're the only one that can do it. So, seems like a case where, they got some fun publicity. The invention from a younger female is inspiring, but in fact, the market says thumbs down in terms of just wanting to buy it. So cool story, still inspirational, should still encourage innovation. They gave it a shot. It just flopped. So that's my wrap up.
Yeah, it seems like an invention in search of a problem.
Yeah.
Right. Solution in search of a problem, I guess is the expression.
Yeah. Right. Cool. Well, Matt, let's call it a day. We worked hard. We hustled.
We worked so hard, and there's still work to be done.
Yes, there is indeed. Well, your day is probably close to being wrapped up. I appreciate you taking time and talking with these fine folks online here, and we'll be doing this again next week if all works out well. I'll be here Wednesday, 1:30 Pacific, to answer questions. Do it again. Hopefully with a guest or two or something specific to talk about if you ask for it. So what you ask for, you get. So bring it on. We'll be here next week. We'll see you guys all later. Go big, go bold.
Go big, go bold at boldip.com.